This is the plaintiff, Sandro Francini. He says he hired the defendant to renovate his condo, and he later found out the guy wasn't licensed. He ended up using the wrong paint, which started peeling immediately. He operated his business under a fictitious name and scammed him out of $2,750, the amount he's suing for. This is the defendant, Marcelo Seidenberg. He says the plaintiff hired him to do some work in his condo. Then the coronavirus hit, and it was spreading. He had one worker there doing the work, but the plaintiff was calling him like 10 times a day, complaining about every little thing. He was almost completely done with the job when the plaintiff fires him, then sues him? Please. If anyone's owed money today, it certainly isn't the plaintiff. He's accused of Crumming Contracting. The defendant has filed a countersuit for $3,500, the money he's still owed.
All parties, please raise your right hand.
Welcome back to the People's Court. Next case on the docket. The plaintiff says he hired the defendant to renovate his condo and then discovered the guy wasn't licensed, so he wants his money back. Now, the defendant says that he started the work, but then the pandemic hit and he could only have one guy at a time do the work, and the plaintiff got impatient and fired him. It's the case of, that's some crummy contracting.
Thank you, Douglas.
You're welcome, ma'am.
Okay, Mr. Francini, you bought a 2-bedroom, 2-bathroom condo in Palm Beach, and it needed some work. So how did you end up hiring the defendant to do that work?
My mortgage broker recommended me to use the services of the defendant on the basis that himself and his wife, a Florida real estate agent, had actually been using the services of the defendant for the past 10 years and really vouching for the quality and workmanship of this particular individual.
Okay, so what is the work that you wanted to have done by him?
I wanted him to do the painting of the walls, the trimmings, remove all the appliances, which were the old ones were actually gifted to him and his employees, as well as finish doing the bathrooms, removing the cabinets of the bathrooms, as well as the toilets, and doing the removal of the popcorn ceiling, as well as replacing it with what is called the knockdown texture.
Right, so go on.
Subsequent to this, he was requested prior to start the job to present licenses as well as insurance, which he failed to do.
So before the work happened, did you, so what do you mean? He failed to, but then why'd you let him in to do the work?
Because he manifested, the defendant manifested that condo associations usually are very difficult to deal with, and the least I would tell them.
So you were doing it under the sly, weren't you? You were kind of under the radar of the homeowners association, weren't you?
Not me, Your Honor, because I actually told the homeowners association exactly what I was going to do. It is the defendant that manifested, because that's his experience, not mine. I'm not a handyman or whatever. To actually decide what is required and what isn't required. And when I presented a copy of the scope of work, which I filled out myself, unsigned by the defendant, they actually gave me the permission. So it is the condo association.
Okay, so stop 1 second. So you applied for the condo association approval of the work, and he signed that document.
No,
is that correct?
Not, Your Honor. He did not.
Oh.
He never signed.
Wow, that would solve, that would have helped.
There is not a single piece of paper that the defendant has ever produced. He has never provided anything in writing at all.
And yet you have given him how much money?
For $2,000 first, $2,000 then, and $931 later.
Okay, I have a question for you. Is there ever any agreement among you two about how much the work would cost?
Yes.
And what was the agreement between you two?
The verbal confirmation that he expressed to me was $4,000 to do the ceiling and the paint. And later on, when he found mold in the laundry, was another $400 to remediate the mold and $931 to install the air purifier in the air handling. And the day he was fired, He left the property upon my request and never filed any request for payment if there was any balances due. So
Did you ever ask to see a license?
several times it repeated in emails.
Did you ever see it? Listen to me. Did you ever see? I don't mean after everything hits the fan. I mean beforehand. Did you ever say, show me your license?
No, I did not because, again, Your Honor.
Are you licensed, Mr. Seidenberg?
I am not licensed as a general contractor. I am not. I work as a handyman.
All right. Do you have a mold remediation license?
No, I do not.
Did you know that in the state of Florida, you cannot do mold remediation unless you have a mold remediation license?
I do know. The reason why we end up doing this is because he hired us first for the removal of the popcorn ceilings and knocked down the ceilings. And right after that,
right. So to be clear, I want to make sure that I understand what is involved here. Let's look at a picture of popcorn ceiling that I am very familiar with. And then he wanted knockdown, which looks like this. Which, why bother? So you wanted to take away the popcorn, but you wanted to put the knockdown. Now, you're handing this guy all this money. You have zero in writing. All you have is verbal. According to you, he's supposed to charge you $5,000, like $4,900 and something, which is actually what you paid him, right?
Correct.
But for a complete job of the interior painting, which you say wasn't done. Tell me the problems and what caused you to fire him.
Okay, what caused me to fire him is if this is the mold remediation that he states he was almost ready to complete, this shows exactly the state at which defendant left the job 17 days after he stepped foot into the property. This is the evidence of the deficiencies that this guy now claims $3,500 for mold remediation, which not only, as you asked him before.
Okay, hold on one second. I want to see this. Hold on. So I have the picture up. That's the picture. What exactly is this? Tell me what the picture should be showing me.
It should show a marble tile, a travertine tile on the floor, the way that he was supposed to have finished it, painted the put sheetrock to cover that orangey portion that you see in the photo and the pipe, and reinstalled at my discretion the cabinet that was removed from there, which is where we discovered the mold was. And
okay, you fired him before he finished all that work, right? Well, so you're saying he can't send me an invoice saying he's owed $3,000, or he can't now counterclaim, which he's doing, $3,000 for mold remediation because this is all the guy did. He sprayed some orange stuff in there. What did you do to remediate the mold? Actually, you know what? It doesn't even matter because whatever you did to remediate the mold, this is very serious business in Florida. The issue of whether you need a contractor's license or you can be a handyman to do ceiling, that's pretty clear you can be a handyman. The issue of whether you need a contractor's license or can be a handyman to do other stuff is it's a little unclear sometimes. But mold remediation, there's no confusion. You're not allowed to do it. And not only are you not allowed to do it, you can be arrested for a misdemeanor for doing it. Criminal. That's how serious the Florida authorities are. What is it that caused you, Mr. Franchini, to finally say, don't come back, I don't want you here?
Poor workmanship, incomplete work. In the issue of painting the doors, which were doors that were actually old doors that needed to be painted, he used latex, where latex can never be mixed with alkyds. So it's an oil-based paint, and he used a latex, which started creating bubbles. And by his own admission, he said to me that they had used the wrong paint. And that had to be fixed by the guy that actually had to hire to finish the work.
Okay, so how is it you fire him? Do you fire him face-to-face, or you send him a text or an email, or how do you fire him?
I sent him an email, Your Honor.
Do you ever answer his email or no?
I never have any emails from him.
At any point in time, you have a counterclaim against him for $3,500. At any point in time, did you send him a bill for that $3,500?
No, Your Honor. No, Your Honor.
So
This
it's
is a-
only once he's
most
filed a
of his
lawsuit
things-
against you that you decided to send that bill.
Well, what happened is, let me explain myself if I can. Okay, this is what happened. We got hired first to do the popcorn ceilings. We finished that thing, and he's like, "I need to paint the apartment," and he had a deadline. He has to do it right away.
Okay, so
that's no
what you
problem.
did
So-
was you painted most of it, but I know that there's stuff you didn't paint, right? You didn't get to because he fired you, right? Like, for example, the new people who come in say that they had to paint the ceiling in the entrance, in the kitchen, and in the bedrooms. That they painted 4 closets, water heater closet, air conditioning closet, linen closets. That they had to peel off, prime, and paint the 9 doors. That's the portion of the painting that they say they had to do because you either didn't finish it or didn't do it or whatever. Is it accurate that you hadn't done that because you hadn't gotten to it yet?
We were 90% finished with that. He was very happy with the paint, how it was going. And then I told him, this is what happened is, he's like, it was like an auction. My job was like an auction, It's like, if I say I want 2,300, I'll give you 2. It was never what we asked for, So, we start.
You mean a
I told him,
negotiation? So
A
how much did you
negotiation.
tell him it was gonna, right, how much did you tell him it was gonna cost, the whole thing?
We start with the ceilings. We got hired with the ceiling, and I told him I can do the ceilings for 3,300, and he's like, "Okay, I'll give you 3,000." I'm like, listen, okay, I'm gonna let it fly. Now, in the meantime,
Okay.
we're like, we have to remove vanities, we have to remove faucets. We also changed in the laundry his spigots. In the meantime, that we're almost done with the paint. The reason why we couldn't finish by the day that he wanted us to finish is because we had a whole other bunch of other things to do that he put in the way. So when we got fired, I'm like, okay, what am I going to do?
Okay,
we're in the
I got
middle
it.
of a pandemic.
So the work you did do was remove the popcorn ceiling, refinish it by doing the knockdown texture. Did you install 1 or 2 fans, ceiling fans?
I think it was 2. It was 2 ceiling fans. 2 ceiling fans. Yeah.
And
My
1 or
workers
2
right
light fixtures?
2.
All right, and you installed the air purifier in the AC handler?
Yes, I installed that myself.
You
I told him that
removed
because-
the appliances?
Yes, we did. Which
Okay.
he's like, he's doing us a favor. Actually, he's not doing us a favor. We're doing him a favor by taking that out,
All right, so here's where we are then. I've got you paying an additional $1,850, Mr. Franchini, to someone else to get stuff completed. But many of the things that someone else did were not even billed by him. I've got a bill from you for $9,400. You're out of your mind, okay? Number one, you're not going to get a penny for the mold remediation. And number two, when you guys don't have a contract beforehand, and it's a swearing match about who was supposed to pay how much for what, guess what happens? You leave it up to the lady in the black dress to decide how much the work is worth.
Welcome back to the People's Court. Now it is up to the lady in black for a final ruling. Let's go back into the courtroom.
I am making the following findings. As to, let's handle your counterclaim first. In your counterclaim, you are asking for $3,000 for mold removal, which you cannot collect because you are not a licensed mold removal person.
Okay.
I strongly advise that you never again engage in that because it is actually a misdemeanor to engage in it. And to engage in it a second time is a felony, okay? As for the $500 for removal and disposal of debris, what I'm gonna do is I'm gonna look at the work that was done and decide what that work is worth, because that's a position you gentlemen put a judge in when you don't have a contract in writing for work that is this many thousands of dollars. By the way, let me explain something to you too, Mr. Franchini. I'm not an idiot. I know when people don't really care to see the license and all that is because they're getting a pretty good deal. Because when you really are very adamant about seeing a license, you say, give me your license number. I know who I hire who's a handyman and who's not, because the handyman is the guy who says, I don't have a license, okay? So, you know, nobody think that I'm thinking that you got fooled or anything. It's just that he was so well recommended. You wanted the work done fast. COVID was upon us, and then it turns out it wasn't working out for you, which is fine. But I get to decide what a fair amount is. And what I decide a fair amount is exactly what you've already paid him. I am not going to order him to return any money. And as for your counterclaim against him, the $500 I'm including in the amount that he already paid you, so that takes care of that. I find the appropriate fee to be what you've already received, which is almost $5,000. It's a lot of work to do the popcorn ceiling. That alone should be $3,000 of it. But I am not ordering him to pay you an additional $3,000 for mold removal for the reasons we've already gone into. Good luck, gentlemen. And next time, get it in writing.
So in this really complex case, it ends up being a 0-0 tie. Nobody gets anything. It ends up the way they came in. So let's see what the defendant feels about what the judge just told him, especially about mold renewal. You learned a valuable lesson, I think. What do you think, Mr. Seidenberg?
Yes, I think, well, she's absolutely right. In this occasion, you know, it was unexpected that the mold was there and he needed to get it out. We were trying to be nice with him. But yes, I will not do no more mold remediation, not even as a favor if somebody needs it.
That's a smart decision on your part. Really, next time you could go to jail. And that's not good. Mr. Fancini, you don't get the $2,750 you were seeking. Sorry about that. What are you thinking?
Lesson learned. I wish him well. Get your licenses so you can represent yourself because you are a nobody. Thank you.
All right, let's see how the judges feel now. There's very complex issues in this case.
For the umpteenth time, Marilyn, you're hearing a case where there's no written contract and the judge has to revert to concepts like quantum merit, unjust enrichment, quasi-contract, and find rough justice and find out what the real amount is that someone should be compensated for and not a penny more, right?
Right.
And how hard would it have been for one of these two to just send a text message one day saying, you know, by the way, I sent you that $2,000, that's for the down payment of X on the scope of the work Y, or whatever, just something to get
to
an
document.
expression in writing of what their real intent was,
right.
To make it a little bit, make your job a little bit easier, and make them be
and protect them. I mean, that's, you know, that's for their protection, for both of their protection, but definitely the homeowner.
Get it in writing.
Get it in writing.
Pamela Ann wants to know this. Hey, Harvey, new tenants moved above me with an emotional support dog in a no-pet complex, and it's running around all night, barking and keeping me awake. That is an interesting situation because under the Americans with Disabilities Act, if this constitutes a disability, if it rises to that level, they may have a right to have that dog, even if there's a no-dog policy. If it doesn't rise to that level, then I think you can go back to the landlord and at the very least say, curb the barking or get the dog out. We'll see you next time.